process as it's written now.
Explain what a 2A grievance is, or I don't know if I'm calling it right, but...
Honestly, the best thing I can say is the whole step of work, but we just want to incorporate that in the current step 2 practice that we have. It's for a denial of leave or a safety issue. It just doesn't really make a whole lot of sense to exclude them to something different. We have a committee working, so in that case too, they're perfectly capable of doing it.
This step 2A is something that's not used anymore, or?
It's used, but there's not a whole lot of respect for it.
Okay.
Even from our side.
Okay.
I won't speak to their side.
All right. If we could have the next slide. What's the next proposal?
That would be to reduce the time limit to submit grievances from 15 days to 5 days.
Okay. First, talk about, it says the pre-scheduled step 1 meeting from 15 to...
Right. All the locals have a labor management meeting and a step 1 meeting. Some of them are the same day, usually one right after the other. Some have on separate days. But they're all scheduled because it's contractual that they have to meet to settle grievances.
So, for example, at SCI Chester, once a month there is a pre-scheduled step 1 meeting?
Yep.
All right. So go ahead.
So what happens is, the 15 days is, I guess that's right, it's like justice delayed is justice denied. It's too much time. And quite honestly, it's going to step on 60 days quite a bit too.
So right now, if you have the step 1 pre-scheduled meeting at SCI Chester scheduled for, I don't know, May 15th, your grievance has to be in when?
Before the end of the week here.
Okay.
Right. So
you're proposing what?
I'm proposing 5 days. In the past, it was written up until this current contract, these last 3 years. It's at a reasonable amount of time. And it was generally accepted as 5 days, 5 business days, or a regular calendar week.
Okay.
I really don't think that's a great inconvenience either. Everything we could possibly ask for, they already have. It's not like they have to send it. We usually ask for very simple things like copies of reports, overtime numbers. It's already stuff they have.
All right. And the next proposal, unless there's questions.
Sure. Specific to that. Tim, are you aware of why the language got added into the contract the last time?
My opinion or the exact, no.
You weren't available for the presentation the Commonwealth did requesting the 15 days?
I was here for that.
Okay. And you don't recall what the rationale was for what? And you made a reference to the discharge case, and you don't want a time issue with that. So that's understanding, the Commonwealth's case is already put together. But what would happen if a local grievance manager or a local business agent or union rep walked into management 5 days before the first step hearing with 60 overtime grievances? You think that's reasonable, 5 days to investigate those 60 grievances and be prepared to respond at the step 1 meeting?
Honestly, we have to be at the facts of each one.
Sure.
But within the 15 days, I don't think that's very hard.
15 days, but you're proposing 5.
No, I'm talking, I have 15 days to file a grievance. That's another 15-day reference. I'm not talking 15 days from the date of the occurrence. I have to file a grievance.
Right.
This is an extra 15. It says 15 days prior to the step 1 meeting.
Right.
I don't really think that's very hard. If you guys are doing the right thing, it shouldn't be very hard. We've never grieved you for doing the right thing.
But you would agree that it takes time for management to investigate a contract interpretation grievance filed by the union.
I can agree it takes time, but
and you and I can agree that there are some locals out there that at times will submit a very large number of grievances at one time, correct?
Are you suggesting that we would warehouse grievances and turn them in all on the 5th day?
All I'm asking is, do you think it's reasonable for a union person to submit to management 60 overtime grievances 5 days prior to a step 1 meeting? And for management to be prepared to respond to those grievances at that step 1 meeting?
60 overtime grievances. Are we talking individual? Honestly, it is very important. You know that. Are they individual grievances or for the entire bargaining unit at will? Because I would say the entire bargaining unit is harder to do in 5 days than 60 individual ones. You can look at 60 individual people on said schedule. If they got skipped over for someone else, that's pretty easy. And then I would also argue with the entire bargaining unit is you have the numbers. Just like I said, you already have the information. It's a matter of doing it.
Brian,
I don't have any other questions.
Just for my information, though, that 15 days was put in the last contract?
Correct.
Okay. And at the Commonwealth's request?
Correct.
Okay, thank you.
Our next proposal talks about listing of cases. What are we looking to do there?
Both the PSC and the PSCOA shall give 30 calendar days notice prior to the listing of any cases for arbitration.
Now, this goes in line with the panel, because you're listing cases on the panel of arbitrators
Right,
list.
and it falls in line to the current practice of what we're doing right now.
Okay. You're actually meeting, are you not?
Yeah, we meet with the OA, DOC, and schedule cases.
And both sides, if not PSCOA more than OA, is suggesting or listing cases? Is that how it's happening?
Yes, we're the moving part. So I'd like to think about it as we fix, settle, or schedule. One of those three things.
Okay. The next case talks about a witness list, 15 days. What's that all about?
Well, pretty much they know who the grievant is. And obviously, if we're talking about a termination case, they know exactly who the person is. Sometimes we like to know who's going to testify and what they're going to say for them.
Okay. And what is there a current provision regarding the providing of a witness list?
No.
Okay. And is there a current practice in regard to the providing of a witness list?
No.
Okay. And then your last proposal, I think, speaks for itself. All the other provisions remain as is?
Not reinventing the wheel, just tweaking them a little bit.
Okay.
Fix, settle, or let's fix
If there's not any other questions, I would move to the next proposal.
Yes.
Thank you, Sergeant.
Thanks, sir.
Now, in the book, there is the current grievance procedure, along with all the other states' grievance procedures for the board's reference. The next proposal, Proposal 6B, is heart and lung. And I'm going to bypass that. Tomorrow morning, we will have Attorney Ian Blen and some witnesses regarding
Okay.
heart and lung.
Okay.
I would then move to proposal number 7. And I would ask that Jim Chernavich come up.
You don't have to be sworn in. Just state your name and spell your last name,
My
please.
name is Jim Chernavich, C-H-E-R-N-A-V-A-G-E.
Thank you.
Could you, this is the first time that Officer Chernavich has testified, so I'm going to ask him some very quick work history questions. When did you start with the DOC?
April of 1990.
Okay. And what has been your involvement with PSCOA?
PSCOA was certified as the bargaining agent for H-1 on June 21st, 2001. Shortly thereafter, in October, I was hired by the PSCOA for a leave of absence from SCI retreat to serve as functional business agent. And I remained in that capacity until June of 2009.
Okay. After being a business agent for PSCOA for a little over 8 years?
Yes.
Did you serve in any other function for PSCOA?
No.
All right. What is your current position with
My
PSCOA?
current position is I'm the assistant grievance coordinator for the association.
And when did you become the assistant grievance coordinator for the association?
That was in August of 2010.
And the Contract Reformation Committee, could you please tell us what this proposal was all about?
Yes, first I'll describe what it is and what its purpose is. I would like this panel to compel both parties to form a committee composed of equal members, 4, maybe no more than 5 members per party, for the purpose of identifying contract language that's no longer pertinent, relevant. There's quite a few housekeeping chores that need to be done with this contract. It's basically been in effect since 1772. And intervening 39 years, it's gotten a little bit messy. There's language that just doesn't apply. There's language that's additionally out of place. we would like that cleaned up a little bit.
Okay. Now, the committee that would be formed, before anything could be done to the collective bargaining agreement, just so we clarify for the board's purposes, both sides would have to agree 100% that that was going to get, that was agreeable, correct?
Bilateral mutual agreement, both parties.
Okay. Now, could you tell us why the association believes this is important? Are there specific examples that you can point to in the current?
I have quite a few examples, and obviously the purpose is it's come to the point where there's actually very few people, in my opinion, that know where everything's at in this contract. And it's on management side, our side, and I think with a better understanding of it, obviously there'll be less violations of it, less grievances, less litigation.
Well, and let's backtrack a little bit now. The current contract that's in place, did this stem from the old ASME agreement?
Yes, this is essentially the old ASME agreement. As I stated earlier, when we certified ASME in 2001, basically ASME had negotiated this contract, PSCOA showed up and signed off on it. So it's basically the same book. And like I said, for 39 years, it's just been additions to this book. There was never a major cleanup operation.
Since PSCOA for the last 10 years?
10 years.
Okay. All right, and give us some examples of what we're talking about here.
Yes, I mean, there's side letters back here, and you could turn to page 159, page 109, for instance. I'm sorry, page 234.
That's in the first one. So if you go to page 234, what do you find there?
Yes. It's a side letter between the parties, April 12th of 1982. And it basically, the language contemplates uniform allowance payment of $100 for psychiatric security aids. It's a classification that doesn't exist in the Commonwealth anymore. It does with corrections officers as well. However, as we saw earlier, there is the uniforms, Article 29, uniform clothing and equipment, the last paragraph. I'll point that page up. That is on 109.
Okay, so that's an example of language or one
No
of,
longer relevant.
that can be just deleted.
Turn the page out.
Let me interject a second, Ryan. It's standard in my interest arbitration awards to say there should be a consolidation of contract and prior awards and so forth, and it's kind of what you're talking about. I can't imagine that the Commonwealth would have any major objection to this proposal. Unless there's more to it than
I've been involved in writing multiple contracts since I've been with the Bureau in 2002, and it's actually the way we do it. Once an award comes out, we typically share drafts, we sit down with them.
Right.
The reason the side letters are actually attached to the back of this contract and were not incorporated as contract language for this 2005 to 2008 contract was at the union's request at the time. Granted, a different executive board, but yeah.
Yeah, what I'm suggesting, officer, is I think that would come standard with my award anyway. Maybe it's a little more work with you guys because you're saying there's some redundancies or irrelevant stuff in there. But you're going to get that with my award. You know, that's the one thing in here that I can probably guarantee you that you're going to get.
Well, wait, if we get one thing guaranteed, we might change that.
Yeah, and, I mean, unless there's more to this than...
Well, that was just an example of a deletion or something irrelevant. There's actually language that's completely like disjointed. It's way out of place.
Right.
It's an issue on leave, and it's back in Article 33. So if one was to look up leave, immediately it's on page 2, there's a table of contents. If you look down to leave, it's Article 10. It's not there. You have to read an additional 170 pages to find it hidden in Article 33 somewhere.
Okay.
And that's the kind of stuff I would like to clean up with their agreement.
Okay. And
Commonwealth is always willing to sit down and discuss issues with the union. I guess the only question I have, and I don't know if there's more.
They viewed that as less than a full commitment.
Moving on. Is the whole setup of the committee, who is going to be, I mean, are we talking about bargaining unit members who are out at the work sites getting more time off than what's already given to them to come and be involved in this process, or is this a process between the union officials and the...
Actually, you're looking at the people. I would like to, with Timmy, myself, maybe Roy, and one of our legal counsel, in addition to your people that work with this thing with me every day.
Not me.
I got plans.